Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision in the case of Merrill Royce versus Michael Needle, the professional company. In this case, this deals a lot with attorney's fees and how much money an attorney is owed, and it is remarkable for its procedural aspect. This attorney really wanted to get paid, really. So they fought for every last dollar for a really long time to what I would consider to be excessive amounts. So we're going to cover this case, and when an attorney really wants to squeeze every last dime out of this rock, could be exciting. Let's get started. This dispute over attorney's fees has a long and tortured history, not because it's unduly complex or involves novel legal issues, but because one of the attorneys, Michael Needle, protracted it every step of the way. He routinely and unapologetically tested the district court's patience, disregarded court orders, and caused unnecessary delays. As a result of the district court sanctioned Needle multiple times for obstructionist and vexatious tactics. This is not language you ever want to hear from a court. If you're being called even obstructionist isn't like as bad, but you use a word like vexatious, you're going to get my attention real quick. The fee dispute arose only because of Needle steadfastly took an objectively frivolous position, and also frivolous is another word that will capture my attention. Some words, when they're used by court, have particular effects that should cause an attorney to pay attention, right? So not all words courts use are created equal. One of these words that's not created equal is vexatious. That's a word that's not created equal. It's a word that causes an attorney to pop up and be like, what's happening now? What? You have my attention. Another one that really causes an attorney to pop up and pay attention is the word frivolous. That's another word that really causes you to say, what's happening now? Like, that's a word where it's like, if the court is saying that, you really want to stop and pay massive attention because bad things are about to happen. He and his co-counsel, Mr. Royce, were entitled to a lion's share, almost 60% of their client's settlement in an underlying suit as attorney's fees, which seems like a lot. But, depending on the fee arrangement, depending on the situation, might not be completely outside the bounds, but it is on the high end. Even Royce, his co-counsel, that's nice, rejected Needle's position. So his co-lawyer said, no, you're wrong, and he's still going for it, nice. Rejected Needle's position because the plain language of the contingency fee arrangement provided that the attorney's fees shall be 1/3 of the settlement, which sounds a lot more reasonable. 1/3, 60% is that's capturing my attention. 1/3 sounds a lot more reasonable. 40% even, it seems a lot more reasonable. 60% is like, no, ma'am. The district court found the same and then decided a sub-dispute over the division of the aggregate attorney fees between them under the separate co-counsel agreement. All right, so we basically have two agreements that are working in tandem, okay? We have an agreement between the client and the attorney, all right, that says, here's how much the client is going to pay. Fine. And we have an agreement between the attorney and another attorney as to, like, what their shares, respectively, will be. Now, this is legal, but you do have to, like, alert the client to it. So in the rules of ethics, if you are going to, like, give part of your money as an attorney to another attorney, you do have to notify the client of it. You have to notify them of this arrangement. So, yeah, you can use the money to, like, give to another attorney, but you have to tell them. So, like, if you hire me and I say, well, I want to hire a lawyer, not necessarily one that already works for me. I want to hire a lawyer as co-counsel or whatever, right? I can do that, but I have to notify you that I'm doing that. Presumably, because then you might want to fire me and just hire them directly. Presumably, that's why I have to tell you, but I do have to tell you. So, yeah. The court awarded Needle 60% and 40% of the aggregated fee. All right, so according to their agreement amongst themselves, the client's going to pay 1/3 total, issue one, and then between you guys, your agreement is such that Needle gets 60 and Royce gets 40. Okay, if that's the agreement you reach, that's probably fine. And unlike the fees due to the client, where the lawyer, they're going to look at it like in terms of its reasonableness. So like if it was 60% total, we're like, whoa, wait a second. because that seems really high. Like the normal contingency is a third, 40%. Could I see 60% in some kind of case? Like maybe, but geez, that's really high. And we're going to look to its reasonableness and a whole bunch of other stuff. But as to the agreement between the attorneys, well, you're both attorneys, right? And you're not the client. So you can probably reach any agreement you want. 95-5, 50-50, whatever agreement you want. We're not going to get into it because it's not the issue, not the client, right? So if you want a 60-40 relationship, that's fine. So you want a 60-40. And Needle was saying, well, I'm entitled to 60% of the whole thing, not just a third, not just 60% of a third. So the argument is that 60% of a third or 60%. Obviously, those two numbers are pretty different. So we're going to go to the wall over this, I guess. At its core, it's a simple contract dispute. It sounds suspiciously like a simple contract dispute. Our retention agreement is a contract. We have a special name for it, retention agreement, but it's a contract, pretty much like any other contract. Although, as I mentioned, it does have some special ethical rules that don't apply to every other kind of contract, like its objective reasonableness, because we're concerned about the client. So there are some modifiers as to this kind of contract that wouldn't necessarily pop up in other cases. It became protracted, however, and developed into a 3.5-year row over with 1,000 docket entries. 1,000 docket entries. That's insane. That's 1,000. I mean, there's definitely been cases with a lot more than that for really complex litigation, but 1,000 docket entries just to figure out what fees are due. In case you're curious, by the way, what a docket entry is, it's essentially, among other things, anytime a motion is filed or anytime a response is filed. So any separate paper, right? Anytime a separate paper is being filed. So if it is and sometimes they can have attachments. So you can do a pleading that has exhibits. So that would still get one docket entry. But because it's a separate paper with attachments, the attachments count as part of the paper, right? But anytime you have a separate paper, it gets a different number. And also my orders from the court and little judgments get there. So it's not necessarily just documents that are filed. Usually, sometimes it's little notices, seriously, they're 2 sentences long, where it's the conference hearing will be on this date, or the conference hearings has been moved to this courtroom, or stuff like that. It can be really, really minute stuff. But for the most part, they're usually papers filed between the attorneys. So if you have 1,000 of these things, man, geez, oh Lord, over a fee dispute, you got to calm down, man. Many, if not most of them, were unrelated to the merits. That's just super exciting. Great. But how did this case come about? What is causing this complexity? This case stems from an underlying civil racketeering, influence, and corrupt organizations action. It's RICO. It's civil RICO. We're in this wonderful place because of RICO. Another reason judges don't like RICO. Yeah. Though not initially plaintiff's counsel, Needle and 2 Illinois attorneys eventually came to represent them. The 2 Illinois attorneys would both later withdraw from the representation, which is never a super promising sign, because, among other reasons, they're trying to argue RICO, and it's not RICO, it's never RICO, so there's that. So Needle recruited another Illinois attorney to serve as co-counsel and local counsel Royce. Needle and Royce entered into a co-counsel agreement that set forth the division of attorney's fees received in the RICO action. Specifically, they agreed to split the half of any fee equally and made the other half proportional to time spent. Okay, this is a really kind of complicated agreement. But again, it's between attorneys, so complicated is allowed. So as to the total amount of attorney's fees, we agree as to half of it. We'll split that half equally. So in the total amount, that's 25%, right? So of the total amount of money, half of it will split equally. So that's 25-25, right? Okay. As to the other half, we're going to do it based on time cards. So you're going to get 25%, I'm going to get 25%, and as the remainder, we'll figure it out as we go. Okay. Together, Needle and Royce litigated the suit for several years, because RICO, before successfully settling the case in 2013. They actually managed to settle a RICO cause of action. They managed to get as far as settlement on a RICO, which for anyone who knows anything about RICO is not easy because courts hate RICO and they will really drag you. So the fact you got to a settlement on a RICO, well, maybe it's because the other side got bored, but whatever it is, you got to a settlement, so good for you. Pursuant to a confidential settle agreement, which is not really that confidential because we're about to talk about it, the parties settled the action for $4.2 million. So according to the confidential settlement, you settled for $4.2 million. So that confidentiality, well, not so much anymore, but, that's what we get to do because we're a court. Ha ha ha. $4.2 million on a RICO. I mean, that's good work. Importantly, sure, the settlement agreement provided for only a single lump sum of the $4.2 million, payable in installments without any further provisions related to attorney's fees, costs, expenses, or the like. All payments were made to Royce as an escrow. Okay, so the settlement said, we're going to pay you $4.2 million, end of discussion. Whereas it's not like we're going to say we're going to pay you this much for this much for this much for whatever. It's like, we are agreeing to pay you $4.2 million. We're going to pay you over this payment schedule. We want this in installments. But all we're saying is $4.2 million. That's the amount due. So it doesn't say anything about attorney's fees or costs or anything else. It just says, we're going to give you $4.2 million. Okay. Instead of bringing an end to the matter, which, it really should have, Needle was not happy with his cut. Needle just sounds like a great guy. He asserted that the attorneys, he and Royce, were entitled to a greater fee amount than Royce and the client group did. So, okay, he says they're entitled to more money than his co-counsel and the client does. So his own co-counsel disagrees with him. The client surely disagrees with him. So he's fighting both his co-counsel and the clients. He just sounds like a great guy. Specifically, Needle wanted $2.5 million, or approximately 60% of the settlement, leaving the plaintiffs and his clients with $1.7 million. That would be 60%, yes. You're going to get more than the client. It's, a little sketchy. Needle and Royce also disagreed over the appropriate division of the fees between themselves. The conflict froze the settlement proceedings in escrow, so Royce filed an interpleader action seeking a determination of the correct disbursements under the contingency fee and the co-counsel arrangement, which incidentally is ethically required in this situation. So if anyone is objecting over the amount, you have to freeze the amount in escrow to the degree it's being fought over. So not to any degree, but over to the degree fought over. So let me give you an example. Let's say that you build 10 hours and you think you're entitled to $400 an hour, which would be $4,000. And the client thinks you're entitled to $200, which would be $2,000, right? This is the hypothetical. And let's assume that there's $10,000 sitting in the bank account because the client paid you in advance. So the client gave you $10,000 in advance, all right? And now we're done. And the dispute is, well, I think I'm entitled to $400 an hour for 10 hours. So I think I'm entitled to $4,000. The client says, no, I think you're entitled to $200 an hour for 10 hours, so $2,000. What do you do? What do you do? This is a good one for all the law students out there. For all the law students out there who are saying under the rules of ethics. Okay? So here's what you do in this situation. First of all, the maximum that under either one of your theories that anyone could possibly be entitled to is $4,000, right? That is the max. They think you're entitled to 2, but you think you're entitled to 4. So the upper limit of the argument is 4, right? So what you need to do, step one, what you need to do is you need to immediately cash a check for $6,000 to the client, right? Because that amount is not in dispute by anybody. That amount is not in dispute. They gave you $10,000 in advance. They think you're entitled to 2. You think you're entitled to 4. Well, $6,000 of this, no one thinks they're entitled to, right? Or neither the lawyer nor the client thinks the lawyer's entitled to it. It's the client's money. No one is disputing this. So what you need to do immediately is write a check for $6,000 to the client. That's what you need to do, step 1. Step 2, what you should do, probably in this situation, what you should do is you should write a $2,000 check to yourself because the money is sitting in an escrow account. Sometimes, it's sitting in a separate account that is distinct from your account because that's how attorneys do these things. It's called an ITAR account, usually. But it's held in trust, right? So it's not your money. So the money that's sitting in that account is not the attorney's money. It is held in escrow. But you can pay yourself $2,000. Why can you pay yourself $2,000? Because it's not in dispute. That's why. The money is owed to you. So you can't keep it in the ITAR account. You can't keep it in the ITAR account because the rules of ethics are clear that once the money is owed to you, we can't just keep it in the fund. So you have to disperse it, right? But that $2,000 is not in dispute, right? Even the client agrees that you should get at least that much. So what you should do, and after you write a check for $6,000 from the ITAR to the client, what you should do is you should write a $2,000 check from the ITAR to yourself, because even the client agrees that you're entitled to it. And then over the remaining $2,000 that's now sitting in the account, because that's the amount that's in dispute, right? The difference between $2,000 and $4,000. That's the amount that's in dispute. Otherwise known as $2,000. That amount that's in dispute, now you go fight about it in some way. So that's what you should do. Write a check to the client for $6,000, write a check to yourself for $2,000, and then argue about the $2,000. That's how you solve this problem. The rules of ethics are fairly clear on this. And so that's exactly what happened here, apparently, right? There's an amount that's in dispute, so we're going to freeze it in escrow while we figure all this out. Fair enough. The core of Needle's position, which underlies this entire litigation, was the attorney fee was separately negotiated during the RICO suit settlement negotiations and included a lump sum settlement amount, thus triggering subparagraph of A of the fee provision. Any fee paid to us pursuant to any settlement agreement. Fine. The district court expressed to Needle on at least 3 different occasions that it had serious concerns that Needle could present this claim consistent with the rules of Civil Procedure 11, which, requires you to have an actual cause of action. So the federal court 3 times says, I don't really think that this would be a viable cause of action. Needle did not heed the warning and continued to assert the claim. So they moved to dismiss and also for Rule 11 sanctions because it was a frivolous claim. Okay. The district court dismissed the count, asserting that the section governed the authority fee determination, finding that the arguments were not merely wrong, but frivolous, disregarding what anyone having taken a first-year contracts class could identify as pivotal legal issues, ouch, and utterly devoid of merit. This dismissal came with an award of sanctions, which is discussed later. It was like, wow, it's like, even a 1L would know that this is crap. Jeez, Lord. Following briefing on the motion to dismiss and the sanctions, Carifty Klobbs moves to withdraw as Needle's counsel. So, Needle, an attorney, as part of his fee dispute, has hired an attorney, which I suppose is a good thing to do. Attorneys need attorneys too. So he's hired an attorney to say, hey, I'm entitled to more money. And this person represented them for a while. And then there was some stuff happened, and then they said, I don't want to represent you anymore because this has gotten to the point of ridiculousness. I can no longer go into court with a straight face. So your own attorneys are now bailing on you. So your co-counsel has bailed on you, the court has bailed on you, and your own attorneys have bailed on you. This might be a clue that maybe you have the wrong position. 2 months passed before a new attorney sought to appear only as local counsel, because I don't want to really appear in this case, but I'll help only for the purposes of the local counsel, sure. And Needle moved to leave to appear pro hoc vice on behalf of the company. So the company itself is the one that's being sued. So we have Needle the person and Needle the company, right? So you need to be an attorney to represent the company, even if you are the attorney, right? So Needle wants to represent Needle the company, but it doesn't have license in this jurisdiction. So we need an attorney to represent the company. So he says, well, I'll do it. I'm already an attorney. Can you give me pro hoc vice status? Which is basically for this occasion. I'm already an attorney. Can you say, well, this business needs an attorney, but I'm an attorney, but not in this court. So can you just let me have it so I can do it? Okay. The district court attempted to address the pro hoc vice application and the issues that went along with it at a status conference. It did not go well. You don't say. The court permitted Needle to appear telephonically at Needle's request, so he did not have to travel from Philadelphia to Chicago. Reasonable enough. It's just a pro hoc motion. So, telephone would probably be fine, so sure. But Needle failed to call the court at the scheduled time. When Needle's local counsel then called him from the courtroom, Needle blamed the court staff for giving him the wrong number. Who believes that? The bigger problem, however, was that Needle took the call on his cell phone in a public forum from a courthouse in Philadelphia. Needle could not participate effectively because of the ambient noise on his end. Wow. Just wow, right? It's like, okay, we want to have a conversation on an issue. Maybe we need to pick a room that's a little quieter. It's not like courtrooms don't have this, right? Courthouses have rooms for like discussions for all kinds of things. So like you could have borrowed one of those rooms, that would have been fine, to borrow one of the side rooms to have a discussion or find a quiet space. But apparently you decide to have this call like in the middle of the lobby or something, and no one can hear you. And you failed to call at the wrong time. What is your problem? That's what I want to know. The court was understandably frustrated, you don't say, and accommodated Needle by allowing him to participate telephonically, and Needle abused the privilege by, having a conversation in the middle of a bus station or something. The court continued the hearing to another date. So continued is just hold it over. So they continued it. So they said, well, we're going to try this another time. And ordered Needle to pay the cost of counsel's in-person attendance at the hearing, which is fair enough. That counsel has to charge their clients, and, they were there, and you screwed this up, so you should pay their costs, which is a perfectly reasonable sanction in this situation. So the court seems to be kind of nice at this point. At the rescheduled hearing, so at try 2, Needle asserted only the lawyer-witness objection to his pro hoc objection was premature. I don't even know. But the legal issues at hand would inevitably require Needle's testimony. Yeah, lawyer as witness, right? So the issue is, if the lawyer is going to be a witness, then you can't also be a lawyer as a general rule. So a lawyer can also be a witness. So he said that the lawyer-witness objection was premature. Okay. And it would seem to me, on blush, that the lawyer-witness rule would apply in this circumstance. Because, although the corporation is legally distinct, it is in fact like the same person, right? Needle is Needle. It appears to be a very small firm. And he's certainly a witness because it was his agreements, his thing. So yeah, he is a direct witness to this. So like the lawyer-witness rule would seem to apply in this situation. So one would presume, all else being equal, he can't be a lawyer because he also has to be a witness, and you can't be both at the same time. So it would seem to me that would be the rule. He's arguing it's premature. Maybe it is, maybe it isn't premature, but I would imagine at some point it's going to pop up, sure. But those legal issues would inevitably require testimony, because of course it is, because we have to determine what the lawyer did and didn't, and so we'd have to have your testimony. And thus it was ripe for ruling. I don't quite agree with that conclusion. Yes, it does require his witness. It will require him to be a witness. But in this frame, it's a limited purpose witness. So I think we can get by with it. We have to have the determination if the lawyer is a witness, and to do that, we have to call the lawyer to figure out whether or not he's a witness to exclude. So like it is a little inception-y, right? So I think therefore, I have to look at the case law and stuff like that, but at least for me, I don't think it quite follows. I think we can allow the risk that you're potentially both at the same time for this very limited purpose, because otherwise, like, we're just chasing our tail. So I don't know that quite follows, but that's what the court said, fine. The court denied Needle's motion to appear pro hoc vice, presumably based on this, and directed local counsel to discuss the scope of representation. 3 days later, local counsel withdrew. So we have another attorney bailing on you. This attorney was there only to be local counsel because the rules require a local counsel, right? I don't think they really should, but they do. As a matter of policy, I don't think that should. I don't think you should need a local counsel. I think it's a little bit weird. What's the purpose of it? I'm not quite sure. But the rules require it. And so this guy said, I'm there only to be local counsel. This is your case. I'm here only as a figurehead. I'm here only as the figurehead, to provide you the ability to do this. And the court said, well, no, I'm not going to allow this. So I want you to try the case. And 3 days later, he said, nope, I'm out. Nope, I'm out. I wasn't here to do any of this thing. I don't want a piece of this. We're off. It's just going great. Needle then went 6 additional months without a lawyer and the litigation stalled. Needle himself decided to ignore litigation, which is always great, by not being on the telephone, not talking to anybody. In an effort to get the case back on track, the court reluctantly permitted him to appear pro hoc vice. So the court is like, okay, fine. In an effort to try this, we'll give you pro hoc vice status. Fine. Further, the court permitted Needle to refile a second amended counterclaims that they previously attempted to file without leave, which you can't do. You have to ask for permission. In doing so, however, the court gave Needle a strict order. File it, but don't make any substantive changes. Okay, you can file it. Okay, you can file it. Just don't change it. Needle obviously understood. How could he not? Responding, I'm not going to do anything other than what I just said about correcting two typographical errors. So the court said, don't change it. And he said, I'm not. I was just going to correct a couple typos. Is that what happened? Mere days after the hearing, Needle indicated his intent to ignore the order and his own promise to the court by telling opposing counsel he is working on revised versions of the amended proceeding, which would add details. What did we just say? The judge held another hearing for the sole purpose of making an already plain court order even more plain. Did you not understand the first time? You can't do this. Nonetheless, later that day, Needle filed a motion for leave to file under seal, attaching the proposed filings that contained numerous changes. What did we just say? The district court was not amused. No joke. The judge nevertheless gave Needle yet another chance to file the complaint. We're going to give us another try. Please just file it without any changes. Did that work? The third time was not the charm. Needle still did not obey the order. Jesus Christ. Because of Needle's stubborn refusal to comply, to refile, the judge rejected the proposed amended pleadings. No joke. This guy is special. What is your problem? At this point, a year and a half after the proceedings and over 300 docket entries, why is this not ended? The case had still not progressed past the pleading stages. Wow. A year and a half later, after 300 docket agencies, we haven't made it past the pleadings. Lord have mercy. I don't know that I've ever heard of such a thing. This is outrageous. You know, if you're in the double digits and you haven't gotten past the pleading stages, you may have a problem. Lord. In addition to the amended pleading debacle and the willful violation of the order, over the course of the next several months, Needle repeatedly and continuously failed to adhere to scheduling deadlines and requested extensions at the last minutes, sometimes on the actual due date of submission, which in turn would upset preset hearings. Man. To make matters worse, how can they get any worse? When he requested extra time to comply, Needle took the time to file several lengthy submissions related to ancillary and unrelated issues. So you're basically abusing all the other latitude of the court. You're abusing all the latitude. Man, what is your issue? Because of the inappropriateness of the conduct toward the limited period since they were granted pro hoc vitae status, the status was again revoked. No joke. 2 years into the litigation, the company still did not have an operative pleading. Wow. 2 years into the lawsuit, we still don't have an operative pleading. We don't have something that's actually binding. Wow. That's just amazing. Jeez. 3 months later, Needle had still not retained counsel nearly 15 months after the local counsel withdrew. Due to failure to comply with the court's repeated order to obtain counsel, coupled with the litigation tactics and the false statements previously revealed, the judge revoked the pro hoc status once again. Royce then moved for an order of default. It's about time, Lord, because Needle had failed to defend the action by not obtaining counsel. The judge was set to retire soon, so the fee action was randomly reassigned to another judge. When the case came to him in 2017, he was 2.5 years old and largely been consumed by needless disputes. Following determination regarding the retainer fee, the Royce-Needle fee dispute, which required that direct participation was sole remaining issue. I don't know why we hadn't had a motion to dismiss. This is insane. The agreement, the actual substantive issue, which we're now going to discuss, finally, Lord. The co-counsel's agreement, which Needle drafted, provided attorney's fees as following. That will be divided as follows. Half of any such fee will be divided equally, regardless of time of effort, 25% each, and the second half of any such fee will be divided in proportion you and I have spent, regardless of an hourly rate. So we're just looking straight at time. Fine. Thus, we come to the end of the dispute, thank God. The district court entered final judgment. The district court precisely distributed the actions to $4.2 million, now $4.0 million, because some of it had been consumed by all this mess, just great, among the attorneys. After the final judgment was entered, Needle moved for a new trial or to alter judgment. This is amazing. What is this guy's problem, man? What is this guy's problem? Massive failures to obey the court. Massive abuse of what latitude the court was giving you. And like after all this, you want to move for a new trial and all this stuff? What is your problem? The fee action was finally disposed of 3.5 years of litigation. It should have not taken anything like this long. It shouldn't have taken anything even remotely close to this long. We should have been able to do it like in 6 months tops. This is amazing. You can only say this guy is really, really greedy. He really wants every last dollar. Man. We review a district court's dismissal for failure to state a claim without deference. We take all pleaded facts as true and draw reasonable inferences in the non-moving party's favor. The attorney's fee section that says, the attorney's fee section says, they'll be entitled to any contingent fee equal to greater of any fee paid to us pursuant to judgment and award of fees under RICO or other fee-shifting statutes, or pursuant to any settlement, or 1/3 of any recovery actually received, with recovery computed by damages and blah, blah, blah. Okay, fine. Needle claims that subparagraph A of the fee controls the attorney's fees as opposed to B. Okay. This is because, according to Needle, a $2.5 million attorney's fee was separately negotiated during the discussion that led to the settlement, which was allegedly included under the lump sum. Under this reading of the provision, then, the subparagraph applies because the attorney's fees is paid to us pursuant to a settlement agreement. Otherwise, the 1/3 floor prohibited would net him far less. This agreement turns upon the contract, so we looked at Illinois state law. It seems like a reasonably easy contract issue, right? It just seems like a very easy contract issue. Like, can't we just get to the actual issue? Apparently, no, we can't do that for some reason. It is uncontested the settlement agreement itself does not provide for the attorney's fees. The settlement agrees that we're just going to pay you $4.2 million and sets forth the payment schedule. There's no term, reference, or hint to the attorney's fees, not even an implication. We could stop here. Yeah. It defies common sense to argue an attorney's fee is pursuant to a settlement agreement that says absolutely nothing of the sort. Nevertheless, Needle insists pursuant to carries a broad meaning that does not demand the settlement agreement state the attorney's fees. Of course, pursuant to can have multiple meanings. Indeed, pursuant to can mean in compliance with, in accordance with, or under, as authorized, or in carrying out. If an alleged attorney's fee is authorized by the settlement agreement, or the attorney's fee is to be paid out in compliance with, or part of carrying out the settlement agreement, the attorney's fees must find its root in the settlement agreement. There must be something, but there's nothing. There's no plausible construction pursuant to that would mean allegedly separately negotiated, non-contractual, and non-identified fee is paid pursuant to the agreement. Yeah, it's not pursuant to the agreement because the agreement says absolutely nothing about it whatsoever. So it can't be pursuant to the agreement because there's nothing in the agreement. It seems pretty clear to me, yeah. Needle's argument also suffers from a factual flaw. Just one. Over the course of litigation, Needle has relentlessly avowed the $2.5 million was separately negotiated, yet he's never identified a separate piece of evidence that supports the claim. Like, whatever. The plain language of the contingent fee agreement dictates the attorney's fee is determined under the section or 1/3 less any retainer. And Railway Hacker, no, I have not covered Prenda law. I've not covered any of that stuff. With all that finally being out of the way, the court must turn to the issue of whether or not sanctions are due. The district court sanctioned the company for filing counterclaims seeking declaratory judgment. The attorney fee is governed by a section of the contingency fee agreement the court has deemed frivolous. They sound frivolous to me. We may have to adopt a new rule on the channel that forbids the mention of other law channels or something. I don't know. But no, we haven't discussed it. Needle was not sanctioned because of its position turned out to be wrong, because it was frivolous, disregarding what anyone had taken in a first-year contracts class, and utterly devoid of merit. There was no attempt to construe the contingency fee according to generally acceptable principles of contract interpretation. Sounds that way to me. I don't know what the problem is. Man, we are really, really greedy for this money, is all I can say. Finally, the conclusion. This relatively straightforward attorney's fee dispute was made exceedingly difficult by one attorney who took a frivolous legal position and turned it into a multi-year litigation conduct. The district court did not err in its ruling or abuse of discretion imposing sanctions, and it is affirmed. So that is the end of our discussion of the case of Merrill Royce versus Michael Needle Company. In this case, we learned that Michael Needle really, really wanted some money for RICO. And, there was no agreement that said, and then they went for 3 years despite fighting multiple orders and all the rest of it. Now, personally, if I were the district court, given all that behavior from this guy, I probably would have said you don't get anything at all. I probably would have said no money for you at all and see whether or not that's an abuse of discretion. The district court actually said that you can get some money, which is amazing, but they did give Rule 11 sanctions on top of it. So personally, if I were the district court at this point, I would have said, yeah, you don't get any money, screw you. But they didn't go that way. So Michael Needle was not happy with his limited award and fought, even though he was disobeying orders and abusing discretion, all kinds of stuff. And so the court said, no, you're just being a jerk. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.